Turning attention now to what happens next for the 19-year-old Boston Marathon bombing suspect. Take a look at, here he is in the white cap, near the finish line on Monday. A group of Republican lawmakers say that Dzhokhar Tsarnaev should not be treated as a common criminal, but instead he deserves to be held as an enemy combatant. Let's bring in our legal panel, defense attorney and former prosecutor David Schwartz, Fox News legal analyst Mercedes Colwin. All right, so I love it when politicians go on national TV and make constitutional declarations like Dianne Feinstein does. She's not a lawyer. She pronounced that it would be unconstitutional to hold him as an enemy combatant. She might have wanted paid attention to the U.S. Supreme Court ruling in April of 2006, in which they let stand the Fourth Circuit ruling that said, yes, you can hold an American citizen captured on soil as an enemy combatant. Exactly right.
And if you read the National Defense Authorization Act of 2012, it says specifically a person who is part of a substantially supported Al-Qaeda, the Taliban, or associated forces that are engaged in hostilities against the United States or its coalition. Isn't that what we have here? This is someone who obviously
And the evidence is the YouTube page with all the jihadist video and some of it related to Al-Qaeda.
And even some family members, Greg, are coming forward. I'm not talking about the uncle who's come forward and said obviously the older brother has some hostilities, but even some family members across in Russia are saying that these are extremists. These are extreme measures. There had to be some sort of connection.
It is the issue, David, of Miranda warnings. You got to be careful that some of his statements in the hospital bed won't be suppressed. That's irrelevant, isn't it?
I agree, Greg, totally irrelevant. There's been such a big deal made out of Miranda. That's the whole remedy with Miranda is if the government violates the Miranda ruling, then the statement is suppressed. They don't need the statement in the first place. There's scientific evidence. There's eyewitness testimony. There are bombs being thrown out the window. There's so much evidence.
There's a confession to the victim of the carjacker.
Sure.
Absolutely, and that's there. So the bottom line is you don't need those statements at trial. The whole point of getting a statement is an investigatory tool to see what else is out there.
Other potential attacks, other co-conspirators that may be out there still. All right, let's talk about the charges. Early on, the president, Mercedes, called this an act of terror. Should the feds prosecute under terrorism statutes and weapons of mass destruction and seek the death penalty?
Undoubtedly. Bring it under those laws, bring it into federal court, because obviously if you put it in state court, you don't have the death penalty. You want it in federal court and get the death penalty in this case.
And look, in seeking the death penalty, you have to prove that the actions of the accused are heinous, atrocious, and cruel. When you set down a bomb next to children, as this guy did, and he's seen on tape doing that, is that heinous, atrocious, cruel?
I mean, there's no question about it. So his whole argument in the death penalty phase of this case, assuming that we get there, will be the mitigating factors, which will be his age, his mental state, maybe he was being coerced by the older brother. These are the type of arguments that he'll be making at trial.
You can just hear the defense lawyers now, Mercedes, say that he was really brainwashed by his older brother. He was manipulated. He was emotionally and mentally easily and unduly influenced.
No jury's going to buy it. When they look at exactly what he's done here, I mean, you know, in capacity, whether he had capacity to understand what he was doing, whether he was brainwashed, many jurors are very savvy. Something like this with such atrocities and such incredible damage to public, and plus the million people that basically were in shutdown for 24 hours, ridiculous.
That's all true, but it may not be that easy during that phase of the case. I think the jury will look at the fact that this is a 19-year-old kid, that we don't know what his mental capabilities were at the time, and the whole coercion aspect of it. I just don't know. I mean, Mercedes is probably right, but I do think there's a chance the death penalty won't be given.
He's a college student. I mean, this is not someone who's so impressionable. He's a college student. He was studying. He had friends.
We just don't know enough about it.
He's not a child.
After the bombing of the Murrah building by Timothy McVeigh and Terry Nichols in Oklahoma City, they had to change the venue because Oklahoma City was just so traumatized by this. You expect to change a venue in this case? Because similarly, Bostonians were pretty traumatized by this.
Sure, especially with
the shutdown.
So you got to
change venue?
I think they're going to try for it. I'm not sure it's going to be emotional. I don't think it's going to be successful, though.
All right.
I'm not sure it'll be successful either, because the whole country was so engaged in this horrible
After the feds
incident.
prosecute, the state could also prosecute on murder and attempted murder, right? There's no double jeopardy.
No,
different crimes.
Exactly right.
Okay.
Exactly.
Mercedes Colwin, David Schwartz, good to see you both.
Great to see you. Thanks, Greg.
Heather?
Yeah.